matter of Lufthansa Technik AG and Panasonic Avionics Corp and others.
Yes, Mr.
My lady, my lords, as you know, I appear in this matter with my learned friends, Mr. Hart and Mr. Copeland, for Panasonic Avionics Corporation, who are the defendant in the action before you, and the appellant, obviously on this appeal, and then the friends, Mr. Cuddigan and Mr. Beebe, are here for Lufthansa, the respondent. Before I begin introducing the substance of the appeal, could I ask the court, by agreement, to make pro tem an order under Part 3122.2 to maintain the confidentiality of various pieces of information in documents in the bundles, to which I may refer in the course of my submissions. Those documents are either documents identified in red in the indices, or it is material which is marked in red in a document which is not otherwise itself said to be confidential. The parties have agreed that's the best way to proceed, so the hearing can go ahead in public.
Yes.
When I come to such information, I may, I think I certainly will in one case, simply invite your lordships and my lady to look at it without reciting precisely what the information says, and we can therefore proceed. And I hope that should be no problem.
Well, that sounds both practical and sensible.
I'm grateful. As you know, this is an appeal...
Sorry, just before you move on,
yes.
I noticed at tab 31 of the confidential supplementary bundle, there is a statement from Mr. Alistair McCulloch.
Yes.
Technically, I think you probably need permission to produce that for the purposes of this hearing. I've read it myself, I'm sure everyone else has. But there's no objection to the...
We don't take a point on that evidence coming in. As we shall say, we don't think it really adds a lot in terms of the merits of the application as a whole. No.
I thought I should mention it, seeing as I know we've all read it. Yes, thank you. Now.
Yes, as you know, this is an appeal from an order of Recorder Douglas Campbell, KC, sitting as a deputy judge of the High Court, in which he made an order that Panasonic were not to be permitted to rely on an account of profits in this case, on figures as to revenue and costs referred to in a witness statement of Mr. Takahashi, which had not themselves been referred to in an earlier witness statement of Mr. Varner. Now, Mr. Varner's statement, as you will be aware, had been provided to meet the provisions of what's called an Island Records and Truing Order, which is an order traditionally made, I'd say universally made, save by agreement of the parties, after a successful action for infringement of intellectual property rights, in particular, as in this case, patents. The purpose of it, I will come to, we've dealt with to some extent in our skeletons, and I'm sure many of my lords are very familiar with where all that goes. Mr. Takahashi's statement was provided in part by way of correction and in part to regularise the position, because the Island Records Order had required a witness statement from a director, which Mr. Varner was not. Again, I'm going to come in more detail to precisely the events and so forth. The potential impact of the decision is financially extremely significant in the context of an account in this case, since the additional costs reduce the profits by a figure that I'm going to state publicly and is publicly in the skeletons of around 30 million. you will see in a moment the detail of that. One particular element, as you will see, is key here to that number and how the profits ended up being significantly lower in the Takahashi statement than they were in the Varna statement. And that was the existence of certain customer incentive payments, of which Mr. Varna had been unaware, and which are connected with the placement of orders. And if I may, just to introduce you to the data that went in on the two occasions. If you've got the confidential supplementary bundle, the Varna figures you will find behind tab 2 at page 17, and the Takahashi figures are behind tab 7 at pages 60 to 61. And it might be convenient in the next little bit of my submissions if you could take out the Varna page 16 and just have it open at, well, page 17, have that open alongside pages 60 and 61, and then I think it'll be quicker to make sense of what changes, what relevant changes have occurred. So both times Mr. Varna and Mr. Takahashi dealt with the revenue, and they both dealt with that in what they call Table A. And you will see the Table A data is exactly the same, comes to the same overall number in the gross column there on the right hand side. I just miss out Table B for a minute. The direct costs, which are in Table C, Mr. Takahashi, are again the same as the direct costs in Mr. Varna's Table B. And then we have various elements included in the indirect costs by Mr. Takahashi, which are not present or not the same as those in the Varna statement, resulting in a discrepancy which you can see from the number at the end of Table G in Takahashi on page 61 and the number at the end of Table C of the Varna statement. So that's the difference in terms of costs as a result of various other elements being referred to by Mr. Takahashi. But by far the bulk of the alteration is due to the sales credit figure. And that comes in under revenue by the way this accounting is done. And obviously you will see that in the middle of Table B in Takahashi as reducing the overall revenue. And so if in fact you add the extra indirect costs to the sales credit, you get the difference between the overall figures. But I've shown you that at least in part to indicate the numbers that we're looking at, but also to indicate the degree of similarity and where the differences are in these.
Sorry, Mr. Purvis. I'm sure I obviously got something wrong somewhere. What I thought you told me was that if I look at the figure at the end of Table C of Varma,
Yeah.
and I compare that to the figure at the end of Table C of Takahashi, I see the difference. But the difference between these two numbers is not 30 million or anything like it.
No, so that's the costs difference.
Right.
Then I went on to look at the difference in revenue. So the sales credit number, which was the point I made earlier, which is the big number, appears in Table B of Takahashi to reduce revenue. I mean, one might think...
Because the big problem was the absence of sales credit.
Yes, that is...
Yeah.
Yes. And that was the real error.
Precisely. I mean...
And now and that's where we see it.
Yes, and that's really what resulted in...
The rest is really just fiddling around the edges.
That's what we say, that it probably wouldn't have resulted in the need to itself change the Island Records disclosure. But this plainly did. As an ignoramus in these matters, I might have thought that it was a cost, but accountants see it as a deduction from revenue. I'm not sure why, but that's just the way it is dealt with in this document. So those are the two statements that we're going to be referring to in terms of the schedule.
It obviously doesn't matter, but just so I understand, comparing your indirect cost figures,
Yes.
Can one identify which component is different?
We probably can, but I would probably want to not try and do that myself now, but I could probably get some assistance to help you with that. You'll see. I mean, it's been done slightly different.
Seems to be a difference
because it's much more generalised in the Varna schedule than it seems to be in the Takahashi schedule, where he's divided it into variable.
I mean, superficially, I'm sure it doesn't matter, but superficially, the figures for corporate taxes are wildly different.
Yes.
And I don't know whether corporate taxes come in somewhere else in the later.
No, corporate tax. Yeah, I don't know either, and I don't personally understand. I have to say why that is the case. But obviously, that's substantially less in Takahashi as a cost. But then there's obviously been increases in the other indirect costs. Whether those 2 points are related, I don't know.
Just sorry, one last question, Mr. Purvis.
Yes.
When you say that in the as it were, your open submissions, public submissions, that the difference is 30 million, is that as in it's about 30 million? Because the difference between the figure of the revenue change and the figure at the bottom of Table G isn't 30 million. It's different from that.
But we've given that as a kind of global number.
Is it useful to know that number without knowing, at least in very broad terms, what the revenue is?
Well, we do know.
I know we know, but in terms of publicly saying there's a difference of 30 million, and one might say that's. I mean, I don't mean you're being misleading, but it could be misunderstood if it was a claim for 30 million, as opposed to if it was a claim for 10 billion. The 30 million out of 10 billion and the 30 million out of a claim for 31 million is really quite a different thing.
Yes. So that's true, and it may be that we can. I mean, your lordships can see what the
I know what it is.
profits are, and maybe we can agree to put a rough number on that.
I think it would help.
I think it would help because for the purpose, I mean, this will result in a public judgment at the end of the day.
Precisely.
And it may be important for people to understand.
I entirely accept that, and again, if I might, I would take instructions on that at some point.
Certainly, there's no rush because it's not like we don't know the figure.
No. So I thought it was useful just to put everything into some kind of context. Again, for the reason my Lord Justice Birss points out, even simply talking about 30 million is perhaps, as you say, not particularly helpful. as you know, and as I've said, Recorder Campbell KC made the order requiring the account to go forward only on the basis of Mr. Varner's figures that had been originally served in purported compliance with the Island Records order. This was, despite recognising, as you've seen and as I'll come to, that the account was at the time of the Takahashi disclosure, and indeed at the time of the hearing, in its infancy, in his words, that the corrective information and the new claim to revenue reduction would not imperil the trial date, that work already done by Lufthansa had not been wasted insofar as they had done work, since much of Mr. Takahashi's data analysis was the same as Mr. Varner's, and that the need to conduct litigation efficiently and at proportional cost had not been significantly undermined, and that the impact on Panasonic of not being able to rely on the corrected figures was substantial. But he considered, as you've seen, that the seriousness of the breach of the original order required him to make the order that he did, because it outweighed those other considerations when applying the Denton approach to an application for relief from sanctions under Part 3.9. Now, can I address briefly the question of conduct and seriousness of breach in that sense? We've summarised in paragraph 6 of our skeleton the matters that concerned the judge. This is very much my summary of what I deduced from the judgment, and I don't think my learned friend takes issue with that as a summary. And of course you've read the judgment itself, in which over many paragraphs he, if I can use the word, eviscerates the conduct of Panasonic when it came to the dilatory provision of the information, particularly criticising the fact that they didn't notify Lufthansa as soon as they knew that some form of mistake had been made. And in no way do we seek to reopen those matters on this appeal, as we've made clear in our skeleton. The decision to instruct Mr. Varner at the outset, Mr. Bennett has explained the reasoning for that in his witness statement on this application, but recognised, because he wasn't a director, in retrospect, that was a bad decision. But the reasoning behind instructing Mr. Varner was not, if I may say, an improper one. He was seeking to find the person who had a most close involvement with the commercial deal, which involved the supply by Panasonic to AES of the items which were held to infringe. This was an indirect infringement case.
The items come from Strike.
Okay. So that decision was a bad one, and as the judge found as a fact, probably resulted in the figures being wrong, because Mr. Takahashi had a better knowledge, or at least had managed to find out about the sales credits, of which Mr. Varner was unhappily unaware. The decision not to inform Lufthansa as soon as it became clear that the numbers were probably incorrect again, was plainly wrong. In particular, when it came a few weeks later to filing evidence about the appropriate confidentiality regime which the judge deals with. But again, there's no suggestion these mistakes were made with some nefarious intent, seeking to gain some unfair advantage in the litigation. Indeed, it's very hard to see what advantage there could be to Panasonic in grossly inflating the profits that it said were being made on the infringing devices. I would only say this, perhaps, in the light of Muller and Friends' skeleton, which repeats its 25 months delay mantra, which Muller and Friends are perfectly entitled to do, of course. But some nuance is needed there. Panasonic first discovered that there were probably errors in January 2021 and first informed Lufthansa that it would be correcting the data in September of 2022. The Takahashi statement with the actual altered data was ultimately provided on the 2nd of December that year. I mean, that does look, when one looks at it, as an enormously long period of delay, which is hugely regrettable. But it should also be remembered that in the vast bulk of that period, nothing was happening on the account. I mean, save for the debate about confidentiality, that's confidentiality club directions, everything stayed on ice until January 2022 because liability was being appealed, a point the judge makes himself in his judgment. And even then, neither party got round to applying for directions as required by the trial order to kickstart the account. Indeed, no step at all was taken until Lufthansa served its points of claim without warning in September 2022. And the other point, of course, is that this whole period was dominated, so far as the commercial part of my clients were concerned, by the pandemic that wrecked the avionics industry, causing waves of redundancy and reduced working practices, which again is dealt with in the witness statements, including in the legal and finance departments of Panasonic. I'm not going to go in any more detail into the detail of it. Those are just the general points that I would make as to the background to this extremely regrettable period of delay.
And just to be clear, when you say no one got on with the account, the election for the account was made in the points of claim, was it?
Yes, at the same time. So we got the election and the points of claim.
Yes, I see.
Even though, in fact, no order had been made for directions as to pleadings on the account at that stage. What had been contemplated in the trial order was that the parties would come back for directions. So far as what I think is probably the judge's main beef, and I don't mean that in any kind of pejorative way, about Panasonic's behaviour, was the fact that they knew that a mistake had made and they never mentioned it. And all I would say about that is this, that the desire not to tell the other side that a mistake's been made until you know exactly what the nature of the mistake is and have the right data to hand is perfectly understandable in itself. And provided everything then happens quickly and you can get hold of the right data, it's probably a legitimate thing to do. What makes it illegitimate is when time goes by and steps are taken, like in this case, the confidentiality debate. Plainly, there comes a point where you've got to let the other side no, and we went well past that point in this case, and we don't resolve.
Or it could have been said that an indication could have been given. Look,
It could have.
we're conducting a review. We
Yes.
think we've probably got this wrong.
Yes.
We'll come back to you, but you know, don't go making an election at the moment because you haven't
Yes.
got the right data.
And that plainly is what should have happened. I suppose if Mr. Bennett could have got to the bottom of it within a week, he might say, well, he was entitled to wait a week before telling them, when he could then give them all the right information. But the time went by, plainly. They needed to know, as you say, because they could, and indeed did, make an election. Of course, at that stage, one can see Panasonic saying, "Well, oh God, they've made an election. We've got to come back and tell them what's gone wrong." And indeed, they did do that. So that's where we are in brief summary, if you like, of the question of what happened and the nature of the conduct. The judge reached his decision, as you know, based on the application of Part 3.9, which was the position the parties both adopted at the hearing before him, as you've seen in the skeletons. And, of course, applied the strict jurisprudence which has developed in the context of such applications after Mitchell and Denton and the very many other cases that have come before the courts on this point, some of which we're going to look at in the course of this morning. The primary point of principle, as you know, which we raise on this appeal, concerns whether this was in fact the right approach to adopt as a matter of law and procedure, whether Part 3.9 and the jurisprudence on relief against sanctions cases applies to the case of a corrective amendment of information provided by a witness statement pursuant to an Island Records order. As I say, we didn't argue this point below, but it is accepted that it's open to us to raise it on appeal. And in summary, if I can put it in its most basic way, the problem with the judgment is that approaching the applications in this case from the standpoint of a relief against sanctions application runs into the immediate issue that there was no sanction, express or implied, attached to any order or rule of which Panasonic could be said to have been in breach. And if that is the case, and I know my learned friend contends the contrary, and I'll come to what he says, then we say it was wrong for the judge to analyse the case on the relief against sanctions basis, because the whole premise of that is that Panasonic, as the applicant, would bear the heavy burden of justifying departure from a default position fixed by the rules or an order of the court, namely, in this case, that they would not be permitted to correct any information that they had provided. Put another way, the position that the judge arrived at in making the order that he did, which was in effect that the delay in provision of the correct information meant that Panasonic's profits should be assessed on a basis which, on the evidence, was factually wrong, and would deliver what I think my learned friend would accept if Mr. Takehashi's analysis is right, a huge windfall to Lufthansa beyond any disgorgement of actual profits, may itself be called a sanction, but it's not a pre-existing sanction imposed either expressly or implication by any rule or order to which Panasonic was subject.
Can I, just as it's in my mind, and entirely out of order and interrupting your submissions, just raise one thing which has occurred to me, and at some point I'd like to understand. Going back to the business of the corporate taxes, those presumably will follow to an extent from what you think your profits are. And therefore, presumably one reason why the corporate taxes are shown in a much smaller figure in Mr. Varner's calculations is that he thinks there's a larger starting profit figure. And so by the time you get to Mr. Taco,
Yes,
I've forgotten his name, I'm afraid, he's starting from a lower base figure, and therefore you get a lower
I think
tax
that must be
figure.
right, because if one assumes, for example, the taxes are based on revenue minus direct costs, that would explain quite a major discrepancy.
It wouldn't explain all of it, but one thing,
Yeah.
just thinking forward,
Yeah.
assume that this order stands, come the taking of the account, are you allowed to say, well, look, Mr. Varner put in this large corporate taxes figure, we'll go with that, even though actually we've paid a much smaller sum in corporate taxes? Or are you only at that stage allowed to claim the smaller sum that you've actually paid in corporate taxes? So that, so to speak, there's an extra penalty.
Yes.
You can't take into account the sales credits, but then you also can't take account of the
Yes.
taxes you were assumed to be paying but aren't.
Yes, if I may, I mean, it is a point I was going to come to in due course. It's one of my points that this is a particularly problematic order because it obliges both parties, in fact, to proceed on a basis that may be factually wrong. And the implications of that, so far as the ability of particularly Panasonic's witnesses to give evidence, is somewhat compromised because they're essentially dealing with facts with assumed facts that they may not consider to be correct. And I think that also leads to points such as the one Your Lordship had just made, that the implications of that are quite hard to follow through. For example, in terms of how you deal with the question of taxation if the numbers aren't right.
Mr. Birss, I mean, you'll deal with it, I think,
Yes.
in the future, but you might want to just take into account why is that really different from what happens routinely in the courts up and down the land when, on the application of Mitchell and Denton, some evidence is not allowed to be admitted. Why is it different?
We would say there is a difference.
Get there in the end, no doubt. But you'll have the windfalls and facts that aren't really the real facts. That's true every time the court decides, which it does very, very often, to not admit certain evidence.
It's a point my learned friend makes, clearly as a matter of principle that's right. We would say this is rather different because it's not merely a matter of excluding some new evidence. It actually involves requiring the party to go to court on the basis of wrong evidence, and that is something rather different. I mean, one might say, I wanted to file a late witness statement from another witness to the accident. That would have benefited my case enormously, and the court say, no, it's too late.
Mm-hmm.
That doesn't compromise the evidence of the witnesses who are going to give their evidence at trial. Or one might have a situation.
Not sure about that.
You've got a very sheltered life, Mr. Birss.
Well, that the evidence of the witnesses which has already gone in was not dependent.
But it
on
might
the
make a
evidence of
huge
the third
difference.
party.
It might make a huge difference
Oh,
because if that witness
No.
that's been refused, that might lead to
No.
liability going the other way, which may lead to huge damages.
I think you misunderstand me. I accept that can make a huge difference to the potential outcome of the case. But what it doesn't do is affect the ability of the witnesses who've already given their evidence to do so fairly in court
I see.
in the normal
Yeah.
way. So yes, of course, the position of the party is compromised, but I didn't mean that. I mean
No, I understand
the position
that.
of the witnesses themselves.
Yep.
Is
What
not
you're saying is
compromised.
that witness A is given a statement setting out the facts as they saw it, description of the road traffic accident or whatever it was, and they can then give evidence in accordance with their witness statement, tested, of course, by way of cross-examination. We're saying that's not the case here because the impact is that any witness giving evidence will know that the information that they're giving is not right.
Yes, and some of these will be accountants coming from outside who have to go and look at the underlying data and facts, and they're going to be put potentially in quite a difficult position if in fact the case is having to proceed on essentially a false premise.
Well, I must say, I don't see the difference at all, Mr. Purvis, at the moment. What if the first witness statement came in from the driver of the car and said that I was in the left-hand lane when the accident happened, and the witness has been excluded is the witness from the passenger seat who says actually they were in the right-hand lane? That's a second piece of evidence which contradicts the evidence of the first witness and might be very beneficial. Actually, it may be that the first witness, according to some godlike version of the truth, was mistaken when they thought they were in the left-hand lane, and they were in fact in the right-hand lane. But their evidence was that they were in one lane, and the evidence which was being excluded said they were in a different lane. That's.
I understand the point, but the position of the original witness, who can only give evidence as to what he remembers, or she remembers, is not compromised by.
That witness still gives their best evidence.
Yes. I mean, clearly, I'm entirely with your lordship that the outcome of the case is often changed by applying Denton and excluding witness statements, but that's not the point I'm trying to make here.
Whilst we've interrupted you and taken you wholly out of course, if I might just ask you one more question, Mr. Purvis, and this is to educate me. As I understand it, the information that has been given so far in both documents is not intended to be the final figure. Its purpose is to assist for the election. So then follows disclosure and so on and so forth, points of claim, get all that, and then it all gets refined, and either there's an agreement as to what the final figure is, or there isn't. In which case it's a trial. And knowing this case, everyone comes back here again. So what I'd like to understand, though, is on the case that we are dealing with, would the position be, in the light of this judgment, that the sales credit are not allowed to be taken into account because that's the decision of the judge? And I'm saying the sales credit because actually that's quite a neat package of what is your main concern. But because the rest of it is all an estimate, that would all be refined to reach a final figure, and that those figures must be correct either by agreement or adjudication.
Yes.
So following on from Lord Justice Newey's point, the reality would be that the real, in inverted commas, corporate tax would be the figure that was taken into account at the end of the day.
I wish I could
Because
answer that.
Because it's not going to be frozen in aspic. I mean, the judge's decision is not therefore that unusually this now is the figure.
No.
You're still going to go through the process, but without Panasonic being allowed to include this figure of 30 million. Therefore, it's...
That
must be right.
At the same point, you could not prove that you had incurred those taxes because you hadn't.
But
there would be no document supporting any such deduction.
Well, except this is actual profit, and therefore we're talking about actual taxes, and therefore it's a little difficult. It's not a hypothetical.
But I think that's what we're both suggesting. Come the trial, where you've had full disclosure and whatever, and the accountants have done their work and they've looked through your figures, they will not find a corporate taxes figure of whatever Mr. Varner had in mind, because you won't have paid it.
Yep.
No, that's true.
$22 million, Mr. Varner.
So But that will
So
result.
it will be versus page 60, wasn't it?
I was a bit wondering
Seven.
where that figure came from. It sounds like it might have been calculated rather
I think actually Mr. Varner explains that he's assuming a corporate tax rate of a certain percentage and applying it to
Yes.
the figure he had.
Yes.
So come the working out of the account on the face of it, where you actually have to produce vouching evidence, you could not substantiate that figure.
That's correct.
So your loss is potentially significantly more than 30 million. It's 30 million plus the
Plus.
difference, potentially, depending on how it worked out, plus the difference between 22 and 7.
Yes.
Sorry to make your day worse.
Well, which we would say makes the results obviously substantially more unfair, and reaches the stage where it can't fairly be said to reflect the nature of the breach, because one's at that point essentially engaging in an exercise of punishment rather than simply excluding evidence. But it may be the natural result, as your lordship already says.
I mean, I just wanted to understand from my point as not being a specialist that I had properly understood what I'd been reading. And
so I think there are 2 points. One is the general point of how these island records cases go, and we've given some account of that in our skeleton, which is that one starts with this rough and ready enumeration of a figure for profits, and that is used as the basis of the election. And then one expects a series of pleadings, as one lady says, and then disclosure, and then evidence from accountants and those involved in the business. And the figures, in my experience, get honed and changed over time as a result of further information and analysis that's done.
do these cases, do they usually settle? Do they usually sort, or do they usually go to trial?
There was a time when they universally settled.
Well,
but
that
seems
would
to
have
be
been my
more and more
feeling.
rare. So, there have been, in fact, quite a few accounts of profits come before the courts in recent times.
Probably good that I'm educating myself.
I would. The first came in my experience. The first case that came on was a case called BP and Hurst, which there hadn't been an account of profits for many decades, and that was in the 1980s or early 90s. But famously, in that case, the case actually settled before Mr. Justice Laddie was due to hand down his judgment, but he'd written it and he handed it down anyway, and came up with a figure which was even lower than the figure for which the defendant had been contending. So,
presumably why they settled. They saw the way the
Might have
wind
thought
was
to
blowing.
try and discourage people from going for accounts
Yeah.
of profits, which it
Well,
seems to have failed to do.
but it's another point that one might think of tangentially in the context of this case, because of course if it's right that the judge can, him or herself, come up with what they regard as the just number from the material that they've been shown, even if it's less than what the defendant is saying, then where does that leave the judge in a case like this? I suppose the point is that he's never going to be allowed to see, assume that must be the case, one of the elements in the assessment of revenue. But if he ever did find out about it, could he not take it into account? Not why not? But
Not.
so,
Well, I apologise. We have
No.
taken, but I think for my part it's been very useful. Thank you, and I'll leave you in peace to go back to where you'd got to, Mr. Purvis.
I'm most grateful. I mean, I was going to come. I can probably now cut some of the submissions I was going to make on island records generally, but you've got it in our skeleton.
Yes. I mean, don't cut it because of
No, absolutely.
we've made you short of time or anything, please.
Sorry, I was on the principle
Yes.
in general of Denton jurisprudence, and the point I was making was that if there is no sanction in the rule, the fact that the judge was making a sanction doesn't turn it into a 3.9 case. I mean, it's not to say that there aren't rules which could be said to give the judge jurisdiction to make the order, other than refusing it in under 3.9. For example, 3.12k, which gives the judge wide powers to exclude issues from consideration, potentially could extend to this case. But our submission is the approach taken under the general discretion of the court, under 1.1, is what one might call the ordinary exercise of discretion, and plainly is, whilst it's informed by some of the public policy matters stated in Mitchell and indeed in Denton, it's not the same thing. And the reason for that, and I'm going to come back to this on a number of occasions by reference to authority, is that there is no default sanction that's already been attached to the conduct, and which in principle should apply in the absence of a good reason why not. And that's why the analysis is different in a 3.9 case to an ordinary case of the exercise of discretion. But rather, the judge is themselves having to craft the right approach to furthering the overriding objective in all the circumstances, using a wide range of tools which is available to him, rather than being constrained by the default position and having to consider whether there's some particular good reason why that should not apply. And I make that point because there's an idea that suffuses Malone-Fren's skeleton, which is that Denton is now a general part of the law to such an extent that you don't really even have to ask whether a case is one of relief from sanctions or not. And we say that is wrong. It matters whether we're in a regime that applies to 3.9. And if I might, with trepidation, cite the remarks of my Lord Justice Birss in the FXF case on this point at Authorities 17, page 329.
If you could give the tab numbers, if
I'm
you have
sorry,
them, that would help.
tab 17, the Authorities bundle, at paragraph 73, which is on page 329. Sorry, paragraph 76, which is on page 329. Well, I won't read it out.
The point you're making is there's a difference between whether the ethos of Denton applies generally to whether you're applying relief from sanction under 3.9, which is what I'm saying there.
Yes.
No?
But you say the question in 9.8, I think you say the question is fundamental to the relevance of Denton itself in this context.
Exactly.
So it does matter, is the point I'm making.
Yeah.
And your Lordship's gone to the trouble in the course of a judgment in which you've agreed with the primary judgment, I think, of the Master of the Rolls, but wish to make that point clear. As we'll come to, we submit that the ordinary exercise of discretion, which features considerations of relative prejudice, proportionality, as well as all the other matters set out in 1.1, could not reasonably have led on the judge's own findings to the order which he made. Fundamentally, Panasonic were trying at a very early stage in the account to make a correction to some of the figures they previously disclosed that turned out, they say, to be wrong. That ought in principle to be allowed, if it can be done so, to do proper justice in circumstances where there's no significant interference with the conduct of the litigation, such as a threat to the trial date, in the absence of true impropriety, and in circumstances where the wrongful conduct of Panasonic in this could be marked, as well as by the strictures of the judge, by cost orders, as the judge himself made clear. And we submit, actually, when one reads the judgment, had the judge been applying discretion in that way, he probably would have allowed the amendment to be made. I mean, just on the events which had occurred, I mean, the only obvious step which had been taken by Lufthansa in the light of the island records information was the election and the service of the points of claim. And it's worth bearing in mind that the Takahashi statement doesn't actually affect the points of claim themselves, since they make no reference to any actual figures, nor do they address the question of Panasonic's costs in the account, save merely to issue a general denial. So what's been served wouldn't itself materially have been affected. Clearly, Panasonic recognised that it was possible that the reduction in profits as a result of the missing revenue data might, in theory, cause Lufthansa to review its election. And it was for that reason that they invited Lufthansa, if it wished, to re-elect, and repeated that offer on, I think, more than one occasion. As you'll have seen, Lufthansa has never engaged with that offer and has refused to say what it would do if the new evidence comes in. But we say the offer on its face deals with what might call a change of position argument, given the early stage in the proceedings.
Mr. Berwin, one of the little bits of this case I've never quite understood is the point you just made, that you say that it's clear that it doesn't really affect the election.
Yes.
The reason what puzzles me, and I don't want to stray into confidential information to do that, but what puzzles me is that, as a general proposition, I always thought the way it would work is if you're the receiving party, you're the claimant, and you know what your profitability would be for the goods in question. Let's say you were a competitor selling rival plugs. You find out, you get the information on island records and trings, so you know how many plugs the defendant sold, and you know what their profits are, and you can do a simple sum which involves comparing your profit to his loss of profit. And since we don't know what his loss of profit is, I don't understand why it's axiomatically obvious that if your profit changes in the way it has, it's necessarily so that the election doesn't change.
That would be the case, my lord, if Lufthansa were in the business of selling rival products. This is a royalty cap on damages. And that's why we say we're tolerably confident that whatever numbers one's looking at here, they're going to exceed what certainly the numbers in the statements are going to be higher than the lordship will have those figures in mind than royalties which are available on the basis of licenses. Right, I was now going to turn to some of the law and authorities. We've summarised the purpose and effect of the Island Records orders in paragraphs 28 to 33 of our skeleton. I'm not going to repeat what we say there. Your lordships will have, my lady will have seen it. The takeaway points, we say, one, are that it's a rough and ready exercise, precision is not required, enough information has to be given to make a reasonable election as opposed to a stab in the dark, and it's always understood that the ultimate figures may and very likely to differ. Phrases like order of magnitude, which I'm not sure is actually that helpful, if taken literally, have been used. I think probably you have to do a bit better than an order of magnitude away. But it's that kind of rough and ready analysis one's concerned with. Secondly, whilst this is often referred to as a kind of disclosure, it's not a form of disclosure of documents. And we're going to come back to Leonard Friend's arguments about Part 31, but one notes that in Island Records, if your lordships have got that on the joint authorities at tab 1, it's very clear from the last few lines on page 7. It's just a passage from B through C. When this, in fact, was here it was an audited schedule was being given, which now wouldn't generally be audited. But it was specifically an alternative to documentary disclosure. We agree, as a matter of policy, some of the things one associates with disclosure must equally apply, such as, in particular, the continued obligation to update if it becomes apparent that new information is relevant or the figures were wrong. We say that really follows as a matter of the duty of litigants. It doesn't require a rule, and it isn't, in fact, provided by a rule of the CPR.
What Justice Lyman there is referring to isn't really an estimate at all, is it?
No, and things moved
he's
on.
Contemplating as an audited schedule or,
Yes.
or as an alternative to the actual documents.
Yeah.
Which, if that had happened in this case, probably wouldn't have arisen.
No, but things have, for
Things
the
have
reasons
moved
we've
on.
given, have moved on a lot since then. But probably largely as a result of the views of Mr. Justice Jacob in Bruegel and Medicaid that we quote at 31. Yeah. And you also see the references in 32 of our skeleton to Vestergaard and Comic Enterprise. So it's metamorphosized, whatever the right word is, from the original conception to some extent as a result of a series of authorities. And I've dealt with the obligation to update, which we say really follows from the general obligation of all litigants to assist in the conduct of the justice process. But we also say there's no rule or order that prohibits the correction of an Island Records statement. One might say in parallel, there's no rule or order that prohibits the service of a supplemental list under Part 31. Indeed, there is a specific order that requires that is done, and a specific provision in the practice direction to that effect. So if one's looking for parallels, it's pretty clear what the position is. Again, I'll come back to that practice direction when dealing with my own friend's submissions on Part 31. But it's important to note, we would say, on whether there is sanction here, that there is no obvious reason why information can't be corrected or a supplemental information provided, and every reason to believe that that is in fact something the court should encourage as a matter of policy, rather than discourage by the application of what can be quite draconian rules. Plainly, if a supplemental statement is given, the court has plenty of case management powers to apply to that. It might well say, well, now you've done that, I think the other side should be given the opportunity to re-elect, for example. Or may make swingeing costs orders, or any of the multiplicity of powers which the court has. But the question here is whether, in principle, the party is prohibited from correcting the information. Because only if that is the case do we get into the situation of having to apply for relief from sanction. And that, we say, fundamentally is where the court was wrong, why it's not a 3.9 case. With that, can I turn to the 3.9 jurisprudence? And I'm not going to go through the lengthy history, which your lordships and my lady will be extremely familiar from all the cases that have come on. I know you've sat in some of those cases yourselves. The policy reasons underlying the decision in Mitchell and the partial dilution, if I can put it that way, of the approach in Denton are well known. There are essentially two matters of concern that the case has raised. It's a matter of policy. The original one in Mitchell was the perception that parties were ignoring procedural deadlines which had been intended to have strict effect and were being excused from consequences laid down by the CPR or court orders, simply on the basis there was no prejudice, and that the effect on other litigants was becoming something that the courts needed to address. And there, as you're aware, the court laid down an approach to dealing with an application under 3.9 that was extremely strict and was intended to ensure the default position would apply by way of sanction, save in exceptional cases. Denton, of course, supports that policy and reasoning, but also notes the law of unintended consequences of taking such a strict approach, namely, if the party not in breach, namely that the party not in breach is given an incentive to be unreasonable, even if there's only a small chance that the breach could result in a claim being struck out. And it was on that basis that the code that's laid down in Denton was set out and continues to apply. But I wasn't going to go any further into that fundamental reasoning because you're so familiar with it. All I was going to show you from Mitchell, if I may, is the point that underlies much of what I'm saying this morning, which is paragraph 45. So we're now in Joint Authorities tab 4. And it's just that first sentence, which is the underlying philosophy that we say is behind all this. On page 59, on an application for relief from sanction, therefore, the starting point should be that the sanction has been properly imposed and complies with the overriding objective. And of course, once you've assumed from the sanction and the fact that it's been laid down by the Rules Committee or by the court making the order, that it complies with the overriding objective, then one immediately reaches the position that the burden on the applicant to justify departing from that is almost like overturning the original decision. And that's why often 3.7 and 3.9 are elided. The burden of doing so is extremely substantial. And that would be by definition because of the fact that the original sanction was deemed to be in accordance with the overriding objective. And we say it goes without saying that reasoning can't apply if you can't actually identify a pre-existing decision by the Rules Committee or by a court to stipulate a particular sanction for a particular default, either expressly or by implication, because otherwise the requisite thought process that rendered the sanction in accordance with the overriding objective has not been gone through by anyone in authority. And we say, therefore, there can be no rationale for applying the Mitchell or Denton approach in strict sense to that application, whether it's for an extension of time or for the opportunity to correct a document. And that, we say, was the reasoning of Lord Justice Moore-Bick in Salford Estates and Altamark, which is behind tab 6. Paragraphs 9 to 10. And again, I don't want in the time to go through all of that. But the key distinction and the importance of the distinction between a case in which there are sanctions prefixed and one in which there isn't is given by the passage from H on 86 to the end of the paragraph on 87. And in particular, the very end there. Most rules, practice, directions and orders do not provide specific sanctions for their breach, leaving it to the court to decide what, if any, consequences should follow. In my view, 3.9 does not therefore apply to such cases, and an application for an extension of time is not one that falls within the scope of Rule 3.9, either expressly or by analogy. Importantly, such applications are governed by 3.1(2)(a). Obviously, this was a case where he goes on to deal with this so-called doctrine of implied sanctions and the circumstances in which that might apply, and I'm going to come back to that in a moment. So, in fact, I'm going to come back to it now, I think. There is clearly no difficulty where there's an explicit express sanction laid down in the rules. The difficulties have arisen where it's hard to identify an express sanction, or there is no express sanction, and it has to be somehow implied from the rules. And even given what Lord Justice Moore-Bick has said in that paragraph, it's recognised in a limited number of cases that the courts can proceed on the basis that there is an implicit sanction in the way in which the rules are expressed or structured to a particular breach. And again, I don't want to go through all the authorities on the history of this discussion of implied sanctions. It clearly was controversial. The Privy Council in Matthews went so far as to say it didn't exist. The Court of Appeal has said on several occasions it did exist, and that seems to be the position now of the courts. But where it has been applied is in a very limited number of cases which have common characteristics, in my submission. First of all, the case of being out of time for serving a notice of appeal, which is one of the most common cases. This was confirmed in the case of Izaj and the Home Secretary by Lord Justice Moore-Bick, again, following the reasoning of Lord Justice Brooke in Sayers. And if you've still got Salford, you'll be able to see at page 87H, so that's tab 6 of authorities. The reasoning of Lord Justice Brooke in Sayers. It's just quoted at the bottom of the page. Equally appropriate, and this was, of course, pre-Mitchell. He's talking about the checklist in 3.9. When the court's considering application extension of time for appealing in a case of any complexity, reason for it, the applicant hasn't complied, the court is unwilling to give him relief from his failure to comply through the extension of time he is seeking. Consequence will be the order of the lower court will stand and he cannot appeal it. Even though it may not be a sanction expressly imposed, consequence will be exactly the same as if it had been. Far better to, so essentially applying it either by analogy or by saying it's an implied sanction, and the two concepts seem to be essentially the same. Because the rules don't permit the appeal to be prosecuted without a notice, if you miss the deadline, there's a clear and obvious consequence that the proceedings have come to an end on which all parties should be able to proceed. And that's so clear from the rules that seeking to controvert it is considered to be effectively seeking relief from the sanction that the case has come to an end. I mean, of course, again, as Lord Justice Moore-Bick pointed out, we're not actually talking about sanctions in many of those cases. We're really just talking about a clear consequence. The question is where you draw the line on consequences. And we submit there is a pattern in these cases. So the second example is a case of being out of time for serving a respondent's notice, and that was Salford Estates itself. I think there probably were other cases as well. And the reasoning there, although it's rather more faint than the reasoning on the notice of appeal, because obviously the action hasn't come to an end just because you're late with your respondent's notice. But the reasoning seems to be that if you haven't served one, you are deemed to be simply supporting the judge. So entire aspects of the case will have fallen away, and the parties should be able to proceed on that basis. And that is akin to the consequence of not serving a notice of appeal. We just remark on that as Mr. Justice Martin Spencer remarked in Mark and Universal Coatings, I won't take you to it because of the time, but it's Authorities tab 11, paragraph 52. The respondent's notice implied sanction is surely very close to the line in terms of how far you can push the implied sanction doctrine, for the very fact that the appeal is going to be proceeding anyway, and it does seem a little harsh, but the courts have gone that far and are prepared to go far. The limited number of other instances where an implied sanction has been held to exist, or the rules have been applied by analogy, extend also to the case of not providing witness statements by trial date, by the date provided for in the directions order for trial, which is the case I think Lord Justice Birss was raising. Now, obviously here there is a specific rule under Part 32 that evidence cannot be called at trial without due service of a witness statement. And the reasoning then is, well, it then follows that the order to provide them by a certain date amounts to an order that if the date is missed, there'll be no evidence allowed at trial.
Can you just remind me what the rule number is?
Part 32 to 10, what my friend says helpfully.
Yes, I see it. So that specifically says within the time specified by the court.
Yes, and that's where I think all the reasoning on the witness statement comes from, and it's again a clean cut-off. Because one's very close to trial as well, it has the effect that parties should be able to proceed and will be inevitably taking steps on the basis of the evidence that's actually being filed. So, again, I don't want to waste time looking at the authorities, but a lot of that reasoning is in the Wolf Rock case, which is at tab 13, which is the decision of His Honour, Judge Paul Matthews, who was sitting as a judge of the High Court, I think. But the reasoning is effectively the same as in Sayers, Lord Justice Brooke. Namely that there is this other rule that kicks in. I should add a reference to the other case, which is very recent, the FXF against English Karate Federation, which I've already shown you that passage from my Lord Justice Birss. That's the case where one's having to apply to set aside a judgment obtained in default, because one has been out of time serving one's defence. And the reasoning there is in paragraph 68. But the reasoning of the Master of the Rolls, just if I can summarise, was that because the rules specifically provide for the consequence of an award of a judgment in default, even though there is a kind of intervening step by the claimant, nonetheless, as a matter of language, it's right to regard that as a sanction. And he essentially finds, as I read it, that it's an express sanction in the rules, in that slightly unusual sense, for not having served the defence. And therefore, the application to set aside is also an application for relief from sanctions. My Lord Justice Birss may have a view on that, but I hope that is
Well, I agreed with
proper.
it.
You did.
Change your mind now.
I hope that's a proper summary. So we say actually, in a way, that falls into the case of express sanctions rather than implied sanctions, if to the extent that it matters.
Sorry, I'm just rereading paragraph 16. Paris, I thought we'd been nitpicking.
Yes. Far be it from anyone to nitpick in this court.
Yes, thank you.
So we say two things can be noted about those strands of authority. The first is that in each case where an implied sanction has been identified, one can find an obvious, specific and procedurally critical consequence in the CPR, which is attached to the failure to comply properly with a rule or order. And the second, in fact, is that in each case the clear consequence is that a specific and important further step in the proceedings was not open to the party in default as a result of the default. Thus, you can't bring the appeal, you can't complain about the judgment, you can't bring evidence, whatever. And they're all bright line positions in which the point of the order or rule is that a clear and immediate consequence will automatically follow from not doing something or not doing it properly. And therefore, it should be deemed to be a sanction. And that is elided with part 3.9. Either by analogy or by saying it is a sanction. It probably doesn't really matter. And we say it's perfectly understandable in all those cases why it made sense to regard them as cases of implicit sanctions. And if I might commend again, without going to it, this was essentially the reasoning of Mr. Justice Martin Spencer in Mark, which we quote in our skeleton at paragraph 43. We've underlined the relevant bit. And my submission, of course, here is that this case doesn't have any of the characteristics common to those cases, those strands of cases in which implied sanctions have been found. And certainly, as Lord Justice Moore-Bick was very clear on, the passage of paragraph 10 of Salford that we looked at, what the cases don't show is that every case in which a rule or order has not been properly complied with, or every case in which you need to apply for an extension of time because you've missed a deadline, attracts the BDI of Rule 3.9 and the jurisprudence that it has attracted. Now, what that negates is arguments that one could conceive of making in many cases. I mean, in Mark, which was the absence of the requisite medical schedule, which was required by the rules to be attached to the particulars of claim a personal injuries case, it could be argued the absence of the schedule means there's a technically invalid pleading, therefore arguably there's no validly pleaded case at all, and therefore there's nothing to take forward to trial, therefore that's a sanction, and so on and so forth. I mean, there's one can take those arguments of indirect sanctions far too far, and plainly none of the cases come close to doing that. And we would say the clearest, well, maybe Millen wouldn't agree with me, but a clear case of the court's finding that that kind of reasoning didn't make sense was Lord Justice Voss, as he was in McTeer and Engelhardt, at tab 9, dealing with cases of supplementary disclosure. I'm going to come back in a bit more detail to that, so I won't show you it now. But all those cases where one could conceive of some kind of indirect consequence of doing what you've done if you were actually held to it, and call that a sanction, if taken to that kind of extreme, would result in courts being inundated with these applications. For example, the example we give, I think, in our skeleton, you're obliged to include all your grounds of defence in a defence, and there's a time limit for serving the defence, but no one ever says that the consequence of not including a ground and later applying to add it is that it's already been barred from being relied on at trial, and you need to apply under 3.9. And all these so-called indirect consequences, are not, in our submission, to be regarded as sanctions, properly so called. And that's frankly the best that can be said in this case about the inadequate performance of the obligations under the Iron Records Order. So turning to the facts of the present case and how one fits them into my account of the law, we say there's no consequence specified in any rule or in the order for mistakes in an Ireland record witness statement, or even for serving one from a person who didn't have the qualifications required by the order. And the order that was made in this case simply recorded, which is at Core Bundle tab 7, but again we probably don't need to turn it up, simply recorded the information in question be provided by a witness statement in a particular form by qualified director by a particular date. Maybe we should just briefly look at it.
Paragraph 10, isn't it?
Paragraph 10 of the order. So it had various requirements of things it had to include, set out at the end. Dates were given, had to be provided by a particular date, and it had to be signed by, accompanied by a statement of truth signed by the director. But obviously no sanction was attached to not doing it, and indeed it would have been, not say slightly odd, but what one notes from this order, from paragraph 11, is that the account hadn't actually really begun, or the inquiry of the account hadn't really begun, so there were no further actions after that the court had laid down that would be interfered with by the need to correct, in principle, the need to correct the original order.
Just thinking round it, suppose you hadn't done this at all.
Yes.
What would Lufthansa then have done about that?
Well, we say they would, if we'd just been recalcitrant and done nothing, they could have gone back to the court and got an order that, I mean, in the end, could have been supported by a penal notice or something of that kind. The obligation could have been chased down in that way.
maybe you don't even need to get a further order.
But-
Well, I suppose it depends when you do it. If you'd served this order endorsed with a penal notice,
Yes.
maybe
But
that would
perhaps.
have been a sufficient basis for contempt proceedings.
Yes, and one could see that in a way because it's so critical to financial relief being proceeded with a tool.
It's always been a problem with inquiries is how do you enforce compliance, because ultimately in a liability sort of case you can always just ultimately say, well, you lose your defence and you'll be found to be liable, but what number does the court come up with if you won't tell the court what you've done?
Well, that's what we say here, that it would make no sense at all to say, well, the sanction is you can't put in an island records order, an island records statement, because then, of course, the poor claimant would have had absolutely nothing to go on to make its election. So it's quite a peculiar situation, this one. It's an unusual form of order for an unusual purpose.
So I suppose you would have had to refix the time and then endorse with a penal notice the order providing for the new time.
I think that's right.
So presumably they'd make that application under paragraph 11 under liberty to apply, and the application would be for appeal to
Yeah.
remake the order with a new
Yeah.
date with the penal order, penal notice attached.
Or I guess they could ask for an order that they be allowed to send in their own accountants to inspect the books. I mean, that would be another way of doing it. So the courts have wide powers to do that as well.
And just extending it, suppose you'd served a witness statement that had been obviously deficient. What would they have done then?
The same would apply. That they apply for an order that it be corrected, I guess in the first instance, if it would, depending on whether any serious effort to comply had been made, some kind of unless order, or simply attach a penal notice. Yes, or make it, unless you provide this information, it's signed by the right person, you make available your records for analysis by the claimant's duly appointed accountant.
I mean, in terms of the unless order, that comes back to the problem you've been identifying, which is unless you do this, what?
Well, that's the reason I suggest the possibility of forcible inspection.
Yes.
And that could be a perfectly reasonable remedy in a case of this kind. Yes. Yeah, and that is part of our argument. We say the position can't be worse than it would be if we hadn't served anything, because we've served something in, we say, good faith, perfectly consistent with the judge's findings, providing data, much of which is right, from somebody who had gone to the trouble of finding out the data, albeit he'd made mistakes. We shouldn't be in a worse position because of that than if we'd never served anything at all. And that again suggests that there's something wrong with the 3.9 analysis. So yes, there's a battery of powers court could use. It might be limited in this case, but one can imagine ways in which the court could deal with it that don't require the concept of effectively barring a party from relying on correct information. Can I turn to the way Lufthansa analysed the position, because it's slightly novel. They say there was an implied sanction here, or possibly even an express sanction, not on the basis of the order itself, but on the basis either of Part 31 or as a matter of policy. So they put their case, I think, in two ways. And one sees that from paragraph 50 of my learned friend's skeleton. And their reference to Part 31, and in particular to the sanction referred to in 31.21, which, if your lordships have it, but I simply read it out. A party may not rely on any document which he fails to disclose or in respect of which he fails to permit inspection unless the court gives permission. And they say this was a case where Part 31 applied to the action generally because the pilot disclosure rules had been disallowed by the original order of Mr. Justice Arnold, and the directions order of Mr. Justice Arnold, which was the order to trial in the original liability proceedings. And therefore, Part 31 applies to the service of the witness statement after trial under paragraph 10. And because Part 31 applies, then Part 31.21 applies, and therefore it's a case requiring relief from sanction. We submit that analysis simply doesn't hold water at all. First of all, we don't accept the premise that Part 31 applied to the order made in the post-trial proceedings at all, for three reasons. First of all, this was a typical split trial intellectual property action. The Island Records Direction, which is the order of Mr. Justice Morgan, as you know, came after the trial on the merits, and we're concerned with paragraph 10 of that order as being the one which is breached in this case. And that was a direction in the prospective inquiry or account, which one can see from paragraph 11. It didn't give directions to trial in the account. Those were in fact given this year on the 27th of April. Just in parenthesis, by that stage, Part 57 AD, essentially the successor to the, or one of the successors to the pilot scheme, applied. You'll find that order in the supplemental bundle at tab 25.
What's the date of that order?
That is the 27th of April 2023, so this is the order of Recorder Douglas Campbell. The only reason I'm referring to it is this, as far as the inquiry on account is concerned, is applying CPR 57 AD and proceeding on that basis as one sees from paragraphs 1 to 5.
Could you give me the page number again, please?
I'm sorry, it's 304, tab 25 of the supplemental.
Thank you.
So we say it's impossible to see how 31.21 can be said to apply to the ability to rely on documents at the trial of the account, which is the sanction sought to be relied on here, if in fact Part 31 doesn't apply to the account at all. So that's the first reason. The second reason is that the order of Mr. Justice Arnold, upon which my learned friends rely as applying Part 31 in default, which gave directions to trial, did not purport to deal in any way with the post-trial proceedings. And there was nothing in the order about that, and indeed it's always assumed that after trial an order will be made which will include things like Island Records and that's
Well,
quite
it'd be a bit
separate.
pointless doing that before you've determined liability, wouldn't it?
Yes, precisely. I mean, I suppose one could have some kind of prospective order in case, but that's never done. And certainly
really
wasn't done.
time with the overriding objective of
Almost never done.
proportionality.
Oh, right.
Sorry.
Well, sometimes the issue really is what's actually at stake.
Yes, absolutely.
It has been done,
But-
I've done it.
In a classic high value action of this kind, it would be very, very rare for it to be done. Anyway, it wasn't done here. All the directions just went through to trial, and there was expected to be another order, as indeed there was after trial, dealing with things like item records. So it's hard to see, we say, how the order of Mr. Justice Arnold's got anything to do with this. And in fact, even if one looks at the order of Mr. Justice Arnold, which is full bundle, supplemental bundle, I've lost it, which was in which tab is it?
I think it's tab 1, isn't it?
Grateful. In paragraph 10, which is the one Malone and Friends rely on. But the first sentence, paragraph 10, which is page 6, provides that save for particular paragraphs in which certain disclosures relating to infringement were provided, parties agreed to dispense with disclosure and inspection altogether. There was no general application of Part 31 to the proceedings. Indeed, disclosure was limited to those specific things. So that's the first point. We say he just doesn't get off first base by trying to bring Part 31 into the case. Secondly, fundamentally, Part 31 is about disclosure of documents, not about the provision of information. And all the rules in 31 concern issues arising out of documents and their disclosure. And one can see that from 31.1 itself. This part sets out rules about the disclosure and inspection of documents. And the whole point, as we've seen, of the Island Records jurisprudence is that it obviates the disclosure of documents, which is the phrase I think used by Mr. Justice Lightman in that case that we looked at. So if it's not about disclosure of documents, then there's no basis for applying the specific rules about documents. And indeed, there's a significant risk if one tried to do so, one would get in a terrible mess, because the whole purpose of this part is to deal with issues that arise out of the existence of documents and their probative value. But we agree Island Records is analogous to disclosure in some ways, in that, as we say, there's plainly an implicit continuing duty, for example, but there's no basis from that to say that a specific rule that applies to documents only, which is 3121, concerned with specific documents and a particular process for disclosure and the rules that should apply in that context, somehow applies to the present case where no documents had been disclosed. And finally, we say, even if Part 3121 did somehow apply to the information disclosed under the order of Mr. Justice Morgan, it is hard to see how that helps Malone and Friends in the present case. Part 3121, so assuming we were considering documents, says a party may not rely on any document which he fails to disclose, or in respect of which he fails to permit inspection, unless the court gives permission. I mean, disclosure is actually very broadly defined in Part 31, in 31.2, as simply stating that the document exists or has existed. And we say certainly if you've actually provided the document, or here by analogy the information, then it's very hard to see how 31.21 can apply, because you have disclosed it. And that actually is precisely what Lord Justice Voss said in McTeer and Engelhardt, a case I promised to show you.
Just before you do, just thinking round that, I mean, it will presumably be said, well, what matters is whether you failed duly to disclose.
Yes.
So if Mr. Justice Morgan's order meant that you had to disclose documents,
Yeah.
then you can be said to have failed duly to disclose the documents.
I think that is what's said, and our answer to that is twofold. First of all, providing a supplemental list. So if we were in the world of disclosure of documents, you're required to provide supplemental list, and there's no bar in providing one. Under 31.12, sorry, that's a bad reference. Under 31.11, duty of disclosure continuing, must immediately notify every party. And in the practice direction, 31A, I don't know if that's, yes, it is behind on the white book. At 3.3, there's a specific provision that if after a list of documents has been prepared and served the existence of further documents which the order applies comes to the attention of the disclosing party, the party must prepare and serve a supplemental list. So we did the equivalent of that. Therefore, if one's trying to apply these rules by analogy, we say we have duly done it, and we can't be criticised, or it can't be said that that doesn't count, and we automatically trigger the sanction.
Mr. Birss, you may say, well, it's not your problem, I don't know, but what would you say Rule 31.21 is there to do? To some extent, some of the submission you've made sounds like a suggestion that you could basically never breach it.
Well, no, I mean, one can imagine circumstances in which one turned up at trial with a document and one never provided a supplemental list. I mean, it does happen. I've seen parties in the witness box pull documents out of their suit pocket, that kind of thing. I mean, plainly at that point, you would be not able to rely on it without permission. I mean, there are...
It's tricky though, because certainly in my experience as a trial judge, it wasn't that uncommon for documents to appear during a trial.
No.
And we didn't go through the 3.9 exercise.
I must say, no. And it's... There are a couple of cases, I don't know if you've looked at those authorities in the bundles in which this kind of point has been looked at in the context of actual disclosure. Of course, our primary point is it's something to do with this case, but it arose in McTeer and Engelhardt.
Which you were going to take us to just before you do.
You keep
just coming back to 31.21.
Yes.
So you say, well, the supplemental disclosure analogy works. For 31.21 to be in point, there has to have been an obligation to disclose a document.
Yeah.
Now, on the face of it, you weren't obliged to disclose any documents.
No.
But query whether, as you say, information is somehow equivalent. If it's a matter of biting only on documents, well, presumably you need permission in respect of every document, because you didn't disclose any documents when when the original witness statement was put in.
No.
You said we hadn't been
Clearly
ordered to.
Clearly that can't. Clearly we didn't need to, because the whole point of Island Records, as I said, was to obviate disclosing the document. So we say that the whole thrust of what's going on here is not the opposite of disclosure, but it's to avoid disclosure.
You say the purpose of 3121 is what happens up and down the country in every county court when routinely people produce documents shortly before or at trial.
Yes.
And this allows the court to deal with it.
Yes. But what it doesn't do is say you can't serve supplemental lists, and that would be a remarkable result if you had to go to court for permission every time to do that. And McTeer and Engelhardt does kind of look at that. I mean, it's not a. I might again, with trepidation, suggest it's not. It's not the clearest judgment, Lord Justice Voss, although what he intended is incredibly clear. And the reasons why he intended it is incredibly clear. The legal analysis, perhaps less so, but the page, tab 9, page 129 is the passage. And this was a case that it was clearly a most unfortunate spat that the parties had got themselves into, because there seemed to be a breakdown in cooperation between these parties. So every time anyone did anything that was late, no one ever accepted it, and they forced them to make applications, and ultimately there was a judgment of Mr. Justice Spearman, I think, saying that they had been in breach, one of the parties had been in breach of various orders to do with serving evidence, and had also in particular taken issue with a supplemental list that had been served, which he said was out of time, should have been included in the original list, and dismissed what appears to be have been an application to allow the documents in the supplemental list to be relied on at trial or something along those lines. The bit I was going to show you to is, take you to, is just from paragraph 45 on 129. There's some complicated stuff about whether an extension of time was necessary at all. But certainly the suggestion is, as a supplemental list, maybe it wasn't, you don't need to apply for an extension of time. As he says at the end of that paragraph, all they failed to do was to include some documents in their possession which they hadn't then found. And then in 46, undoubtedly the safest course, he says, would have been to apply for an extension of time, if necessary, for relief from sanctions, though he doesn't explain why that would be necessary, and for permission to rely on the new documents. Application should be explained by an explanation of why it was in the first place. But the point is, this was very, very late in the day prior to trial. 47, the judge relied on 3121, which only provides that a party may not rely on any document which it fails to disclose unless the court gives permission. But then he says, but by the time of the hearing, defendants had not failed to disclose the new document. They had served a list in respect of them. And that, we say, is plainly right. Therefore, there's no breach. I mean, the only slight oddity is he then goes on to say this: the question, therefore, is whether the judge is right to treat the application in relation to the new documents as purely one for relief from sanctions. I don't think that he was. I mean, we would say, well, given his analysis, the word purely doesn't actually make much sense there. He's clearly saying, was he entitled, should he have treated it as an application for relief from sanctions at all? I don't think that he was.
It is difficult to construe that part of that paragraph.
Yes. It's very hard to understand. I mean, we would say it has to be one of the, it's either one, either falls into that category or it doesn't. There's no such thing as a kind of impure application.
I mean, there could be a sort of halfway house where you do go through the relief from sanctions exercise, but an important factor in that exercise is that you're dealing with it specifically in the context of disclosure, which could have all sorts of implications.
That's possible, but it doesn't make much sense in the light of paragraph 47, we would say, because if you follow paragraph 47, there hasn't been a breach, and therefore there isn't a sanction. So that I'm entirely with you, Lordship. I think that's the difficulty with it. But we heavily rely on 47, which in our submission makes perfect sense. And I've shown you the rules in the practice direction. requiring service of a supplemental list and not saying that it needs permission.
Sorry, I'm not sure I'm following what you're saying. I understand the point you're making, Mr. Purvis, that 47 makes clear that
Yeah.
having done what happened, there's no breach of CPR 3121.
Yeah.
See that?
Yeah.
But wasn't part of what was being said that there was a breach that might have been regarded as a breach of an earlier,
Yes.
at an earlier stage by not producing the documents in the original list?
Well, except that he says, well, as I understand it, what he says about that is that they simply hadn't found those documents at the time, therefore couldn't include them.
Yes, I see. Yeah, okay.
Which is the whole point of the provisions for providing supplemental lists.
At the same time, if you look
Orders
on
of sanction.
to 49, he's doing what on any view might be thought to be a CPR 31.21 exercise. He's asking himself whether it should be permissible to put the documents in or to rely on the documents.
Yes, he's said, as he says, the important question is, can you rely on them?
And I mean, that is consistent with 31.21 applying.
It doesn't apply
Certainly-
Denton.
But he doesn't apply Denton. Or doesn't
No,
obviously
he doesn't
apply
appear to apply Denton. I mean, essentially, he seems to approach the case on the basis that, well, I should consider what's right, and it would be crazy not to allow these documents in.
Or is he actually, is this consistent with the Denton analysis? So the first sentence is significant breach.
Yeah.
Then third sentence, there was an excuse. Well, that's the second stage, good reason. And then the rest of it, I suppose, is third stage.
Well, yes, but yeah, hard to know. But we do say,
But at 48, he does say that he doesn't think it should be treated as purely one thing.
yeah.
I'm not sure how much we're going to be able to take
No.
from this.
I mean, I thought I ought to show it to you.
Thank you.
A load of friends rely on that reference fails duly to disclose, which was the Soccer and Namely case for Lord Justice Stanley Burnton, construed 3121, but for the reasons I've given, we say it doesn't help them because you are permitted to serve supplementary documents. Indeed, you're required to do so, so you have duly disclosed. And we say a proper analysis, however one looks at these authorities, is that there is no breach in serving a supplemental list, and there is no bar or sanction to relying on those documents. And again, it would be an extraordinary position that would require multiplicity of applications in many cases, if that were the case. Supplemental lists are commonly served.
Does it depend on what's going on? I mean, I just wondered whether the answer is not as simple as you've said, because a case in which you give your main disclosure in good faith, and then again also in good faith, you find more documents which don't falsify the idea that you did a reasonable search the first time. That sort of supplemental list is not a breach of anything. It might be said it's not the same as a situation in which there are documents that you find the first time round which you decide to not disclose. Then later you think better of it and decide you should disclose. Now you may say, well, no one ever finds that out, but that's not necessarily so anyway. But if those are the facts, those two supplemental lists are not really the same as each other.
No, one would then get. I mean, that would add even more to the burden of conduct of litigation if one then had to distinguish between those scenarios in each case and go to court to justify which one applied before you'd worked out, particularly if that was necessary in order even to work out whether 3.9 applied.
Yeah, but I mean, you might never know, and it might never come up. But if it did come up,
no. What we would say, Your Lordship, is identifying is a possible situation of breach of an earlier order for which no actual sanction is provided. I mean, one has nonetheless duly disclosed the document, and to expect an investigation into this kind of thing in every case would be procedurally extraordinarily difficult. And we say none of that can be found in Part 31. Anyway, we say it clearly doesn't apply outside the context of documents. So we said 3121 doesn't get my learned friend home, nor can it be relied on in some way as establishing a policy rule which should be applied in this case to island records and Tring statements. Obviously, if we're right about the effect of 3121 on documents, then we must also be right by implication. One can't read that across to island records and Tring statements. But we say there's no reason anyway to apply some kind of policy-based sanction that doesn't reflect the existing authorities, effectively deciding after the event whether a sanction should be invented by the court as a matter of policy for a particular kind of conduct. And then to say, because we've invented that sanction, an application for relief is necessary, and you failed to meet that requirement. The right approach, we say, is to consider whether the case satisfies the established rules on cases that amount to the need to require relief from sanctions. And we say those rules are relatively well established for the reasons I've given about on the basis of cases like Salford and Altamont. And we say there are many policy arguments, in fact, for not treating a correction to an island record which is requiring relief from sanctions. First of all, of course, the very fact that they're intended to be preliminary and rough and ready is itself rather inconsistent with the idea that no mistakes can be made. One ends up in a situation where one has to judge the gravity of the mistake before working out whether it attracts a sanction at all. I mean, these are intended to be superseded by detailed pleadings on both sides, as we know, and then disclosure. That's very different in principle and effect from a specific obligation to hand over documents relevant to pleaded case. Secondly, one considers the information, the real reason why there was a breach here by not including the customer incentives in the revenue was that this was a cost on which Panasonic intended to rely, and that was a requirement of the order itself. It had to set out those costs on which it intended to rely. That was the point the judge makes. But that, of course, is rather more similar to a pleading than ordinary disclosure, because what you're doing is saying, here are the things that at the account I will be saying are things that should be deducted. And of course, if this case is more allied with something like a preliminary pleading as opposed to disclosure, which is a perfectly fair way of looking at it given the nature of the order, then it can't possibly be a 3.9 case, because it's essentially an application to amend the pleading where one said one hadn't included one of the things that one wanted to deduct. And notably here, Lufthansa have already made substantial amendments to their pleadings, running new points and new claims, which have nothing to do with the Takahashi issues, and we've agreed to those coming in. That's exactly what all the parties would expect. But we say there's no policy reason to treat what happened here differently from other mistakes, for example, mistakes in pleadings. And indeed, it may well be said that introducing draconian rules that would discourage the correction of mistakes because of the sheer difficulty in doing so aren't necessarily to be regarded as useful for encouraging the overriding objective. I should turn to what we say as a result if 3.9 doesn't apply. I've dealt with the point that, well, it's all the same anyway. We submit it isn't for the reasons that I've given and as recognised by Honourable Lord Justice Birss in the Karate case. And indeed, if it didn't matter, as suggested, and as suggested by my own friend, that's been clear since 2013, then it is amazing how much ink has been spilt by the courts in trying to work out the extent of the requirement to seek relief from sanctions. Well, then, friend is right, those cases were apparently engaged in a pointless debate. Not to say there aren't cases where the outcome will be the same. That, of course, is not the same point. And I repeat what I've said before about the reasoning of Lord Dyson. If there is a sanction that's already been deemed to be the right approach, it's quite obvious that trying to overcome that sanction is a different operation from simply considering the case as a whole on the basis of the overriding objective. What is the position here then if we're right that it's not a 3.9 case? The judge made a number of important findings in our favour on this in his decision. And if I might just run through those, the judgment is tab 9 of the call bundle. I just wanted to show you paragraph 75, where he makes a point which he makes elsewhere as well, page 97 of tab 9. Paragraph 75, the account's in its infancy, and I don't believe the trial date is imperilled. Indeed, very hard to see how it would be imperilled, given the stage that the proceedings had reached.
Would that be true even if there were an election in favour of damages?
Yes, we say, well, I'm going to come to that point if I may. Yes, we do say that, absolutely. And indeed the judge himself appears to accept that as well. Paragraph 78, Lufthansa argued before him that a huge proportion of the work that they'd done looking at the numbers was going to be wasted. I mean, quite how much work was unclear, but that's what they said. The judge rejects that, and he says much of the work done will continue to be relevant. And in fact, I've shown you how a lot of the figures are in fact the same, as the judge finds in paragraph 78. Paragraph 82, he says that the need to conduct litigation efficiently and at proportionate cost, so here is running through the checklist, has not been significantly undermined for similar reasons. There may be some waste, but it's not the extreme waste that Lufthansa has suggested. 83, cases no more complex as a result of Takahashi than it was in light of Varna. 95, he deals with the point on the election to say Lufthansa hasn't suggested it would have elected a different way based on Takahashi. I've got to come to that very briefly on the respondent's notice, but that is what he says. And then in 97, he says this, which deals with my Lord Justice Newey's point. Lufthansa has made various submissions about what it says are difficulties if either course, account or inquiry is adopted. But it seems to me these difficulties are not such as to prejudice the trial date and could in principle be compensated for in costs. Malone friend now decides to say, oh, well, if we go for an inquiry, who knows, we might miss the trial date. There's no respondent's notice challenging this finding. And we say the judge has looked at it, he's looked at the evidence on it, and he's considered that the trial date's not going to get affected either way. And yes, compensated for in costs. It's common ground, of course, the parties are well resourced. It's common ground the case is sufficiently important to justify significant expenditure. And without a trial date being imperiled, it's very hard to see what damage to other litigants is caused by allowing this new evidence in. And we submit that all points one way on the exercise of discretion. We accept clearly that cost awards to deal with wasted costs are inevitable, and they can be made on punitive basis if the court thinks fit. And no doubt this judge would have done so given his findings about conduct. But essentially what's set against it is an argument of punishment, which we say is not the right approach, and particularly in circumstances where it's not suggested the wrong information was provided out of some desire to mislead. It's impossible to see what possible benefit could have been obtained so far as Panasonic were concerned by doing what they did, nor even that the delay was engineered for some nefarious purpose. Mr. Bennett's approach was wrong. We completely accept that, and we accept the criticisms of the judge in their entirety. But we say, for the reasons I gave earlier, one can see how it happened, albeit it should never have happened. The conduct has been criticised, it's been taken on board, and cost consequences must be borne by Panasonic. But there's nothing here to justify the order that was sought or made. Can I then briefly deal with what my own friend says about discretion? He says, first of all, if he decides to elect for damages, there will be a lot of wastage of costs and other difficulties. That's his paragraph 61 to 68. 3 points to make about this. First, the judge has already dismissed it. See paragraph 97, the respondent's notice. Second, we say it's actually quite plain Takahashi has not caused Lufthansa to want to change its selection. Otherwise, they would have said so. They've had this information for an extraordinarily long time now, with the way this application has gone and been appealed. We submit, if they do make a decision to re-elect, it won't be on the basis of Takahashi, for reasons that I'll come to. The judge noted two powerful points on this in his paragraph 95. First of all, that Lufthansa had not taken the opportunity to re-elect. And secondly, that the gauntlet thrown down by Mr. Bennett in the evidence that the claimant would have made the same choice even if Takahashi had been originally served was not taken up by Mr. McCulloch at all. My learned friend puts in a respondent's notice on the first of those points, effectively saying this is a bad point by the judge because we couldn't have accepted the offer to re-elect without agreeing that Takahashi should come in, and that our primary position was that it shouldn't. Which is a fair point to this extent, that would have been the result of re-electing. But of course, what he could have done is respond to the offer by saying, we dispute your ability to rely on Takahashi. That's our primary position. And we would prefer an account based on Varna to one of damages. But if you're allowed to rely on Takahashi, we will re-elect for damages. And they didn't. Never said that that's what they would do. Because in our submission, that has never been their view, for obvious reasons, looking at the numbers. And it's extraordinary that they still won't say what the position is. And the only obvious conclusion we say is they're trying to maintain a fiction that they might elect for damages in order to point on this appeal to the risk of all the costs to date being wasted. And that the fact they don't deal at all with the judge's second point in paragraph 95 is telling. The only possibility as to why they might elect for damage, interestingly, is what my learned friends say in paragraph 69, which was a bombshell in their skeleton. So as a result of the pleadings now being in, so learned friends actually getting rather a useful windfall in this sense, that of course it's now being able to elect post-pleadings as well as post-island records. And he says in 69, because of the way the case has been pleaded, and there's an argument running in the pleadings which effectively says because there were other equally profitable things, you shouldn't actually award anything by way of profits. We could have supplied something alternative. There's Canadian jurisprudence along the lines that might be a good argument. It's effectively a legal argument. Learned friend accepts in 69 that this didn't have to be foreshadowed in Island records. It's only come out of the pleadings. Well, learned friend says, oh, well, having seen that, I might want to re-elect. But of course, it's got nothing to do with Takahashi at all. And if one considers it for a moment, it's a huge benefit to my learned friend as a result of the various matters that have happened with regard to Takahashi. Because this thing has been kicked on so long that the pleadings have occurred before he has to re-elect, he gets this useful benefit. We say that can't possibly help him on this application. Finally, they say they might re-elect for damages against Panasonic whilst maintaining a claim for profits against the other defendants, and that might cause the costs to increase and somehow threaten the trial date. We don't accept that at all. First of all, there's no basis for the assertion this would create any difficulties. Indeed, on the face of it, a damages inquiry would be a lot easier in this case than the determination of profits, because one's simply looking at a reasonable royalty based on established license rates offered by the patentee. We say costs and time would be saved if this is an ordinary account, and certainly no reason to suppose that it would be more difficult.
When's the trial? Is it May?
October.
October.
So we say costs and time would be saved with Panasonic, costs and time with the other parties would remain the same, so there's no there. Second, it's got nothing to do with Takahashi. If he does re-elect, it's on the basis of 69, quite plainly, which has got nothing to do with what's happened here. Thirdly, it's bizarre speculation for Lufthansa to make these points while studiously avoiding saying what they actually intend to do, and the court should view that with huge suspicion anyway. This is a kind of game-playing exercise. And we say the allegation this cause will imperil the trial date in October next year is a wild allegation without any foundation in evidence. Secondly, they rely on the somewhat self-referential argument that there's been wasted costs involved in these applications. Well, that's always going to be the case. And in fact, of course, if we're right, then they ought to have accepted the evidence and avoided the applications anyway. So we say that argument kind of chases its tail and gets nowhere. And third, they rely on the waste of costs to date. Again, we say the judge has already dismissed this in paragraphs 78 and 82. There's no respondent's notice on that, and the points raise nothing that can't be remedied in costs. I've dealt with the main ground of appeal. We have got the other grounds of appeal as to the judge's actual approach to denting, which I should run through. Your lordships and my lady have seen them. I'm concerned a bit about the passage of time. I did want to finish probably about 10 minutes ago, but I've gone on. But if I may just deal with those which shouldn't get lost in the appeal. The first extra So this is an argument that his application of Denton third in law. And the first point is that he didn't separate out the question of significance from seriousness, and those are two very different things. And we deal with that in our skeleton from paragraph 54. And we say when the judge deals with the first Denton step, looking at seriousness and significance, from 74 to 77 of his judgment, he really only looks at seriousness, and he doesn't do what he should have done, which is to say, in the light of my other findings, this actually isn't a significant breach, because it doesn't have a material effect on the conduct of the proceedings. And we've given citations in our skeleton as to why that's the right approach. You'll recall from what I've already shown you, the judge's various findings as the effect of the breach hadn't had any great impact. And we say, if significance in Denton terms involves looking at the consequences of the breach, which we deal with in our skeleton from 61 to 63, and we say it plainly does, then the judge should have brought that in at this stage. He should have said, yes, it's serious, but it's not particularly significant. Now, my learned friend points to his reason in 76 of the judgment, where he does use the word significant. He says that the statement was significantly inaccurate. But in our submission, that actually just means seriously inaccurate. That's not the concept of significance with which Denton is concerned. So we submit that doesn't actually help. The judge has found rightly the breach was serious, but he should have taken into account the fact that it wasn't particularly significant or material. Having not done that, he's sort of undermined his own judgment. And indeed, when one actually turns to his judgment, ultimately, it's very clear that he simply finds against us on the basis of the fact that it was late and that it was seriously late, and the conduct associated with it being late was not acceptable. So that's the first point. The second point is that he didn't consider the proportionality of the outcome of the order. And we deal with that in our skeleton from paragraph 72. And we quote the judge at 84, where he deals with the fact that it's financially very significant, but he simply dismisses it on the basis that, well, that just goes to show why you should have got it right in the first place. Now, that eventually, in any case, that would just exclude any argument that the effect of what was being sought was deeply prejudicial, because you'd always be able to say, well, then you shouldn't have done what you did. And it's with respect to the judge, a bit of a trivial response to something that he plainly ought to have weighed in his discretion, and on the face of it, he isn't weighing it at all. Of course, you can say the seriousness outweighs the prejudice, but you can't ignore the prejudice. And on the other side of the equation, which we deal with in 74 to 79, the judge in his judgment in 96 clearly relies, on the other hand, on Lufthansa losing its 30 million windfall. Now, again, that is the simple point that it will be worse off if relief from sanctions is granted, and hence it's inevitably prejudiced to that extent. We say that's a clear reference to them losing the windfall. And we say that's simply a wrong analysis. It can't be relevant prejudice, because if we're right, they're not legally entitled to that and never have been. And the learned friend accepts, in principle, that the judge wasn't entitled to rely on the absence of a windfall. But what he does is try and say, oh, well, the judge didn't mean that, And he was in fact referring to procedural prejudice, which we submit can't be right, because the rest of the judgment makes it clear that he doesn't think anything of their procedural prejudice argument. And the phrase "worse off," we submit, must surely relate to the financial remedy.
I mean, earlier in his judgment, the judge had referred expressly to the need for litigation to be conducted efficiently and at proportionate cost, and to enforce compliance with orders. And then he noted that the breach undermined the purpose of the order made by Mr. Justice Morgan and the Island Records regime. I mean, aren't all those fair points?
Yes, all fair points.
So he's put those in the scales on one side, and then he looks at all the things going your way.
Yes, but it also, in order to dilute the things going our way, we say he is wrongly brought into the equation. He's effectively said, well, if you might be losing 30 million, but look, Lufthansa is also losing 30 million if I allow the evidence in. And we say that's a false analogy to say that the two are a false equivalence between those two, which my learned friend accepts. And therefore, he's ended up effectively just negating the prejudice which Panasonic will suffer as a result of the order, which ought to be taken into account. Of course, it could be.
And what test should we be applying here? Is it a judge took something wrongly into account, failed to take something correctly into account, or is it, he went outside the range of outcomes available to him?
On these 2 points, we say he wrongly took something into account which he ought not to have taken into account as a matter of principle. And had he looked at the case the right way, weighing up, applying Denton, getting the significance as well as the seriousness into the equation, recognising that the 30 million was a serious point and wasn't negated by Lufthansa's loss of money, he would have come to a different view. And I think it's always hard to say it was outside the bounds of what any reasonable person could have done, unless one has all the correct findings of fact laid out in order to address that issue. Here we say if he'd laid it out all correctly, then any reasonable judge would have acceded to Panasonic and would have rejected Lufthansa's application. Our final point is the judge hasn't considered alternative ways of dealing with this in terms of penalising Panasonic in costs and the like. He seems to have taken the view it's kind of all or nothing. And we say again, in the exercise of discretion, you have to have in mind alternative remedies, and that there's no indication in his decision that he's even considered those possibilities.
I mean, if that were a strong point, I suspect it could be deployed in so many cases.
Yes, I mean it is deployed occasionally.
But routinely, it must be the case that, say, district judges making decisions on these things go through the Denton, Mitchell questions, and they don't then expressly say, well, I have to think about whether to do something different.
No, but we would submit it's an important intellectual exercise for a judge to make him or herself go through that exercise. Because unless you are familiar with the alternatives, it's not possible to decide that this is the most appropriate thing to do. You're simply deciding it is an appropriate thing to do. But that shouldn't be good enough if there are other options. And you ought at least to briefly explain why that's not the case.
I can't remember if we have the skeletons from below. I don't think we do.
We do have them. They may be in the bundle somewhere.
Did you make that point to the judge that he should Can you measuring costs instead?
Personally, I wasn't there.
Would your side make that?
And I haven't got a sufficiently photographic memory, but we have got these documents in the case.
Okay, well, you can
Yeah.
you want to give us a reference over lunch or something.
I will, if I find it, then, or in the transcript or anywhere else, we will of course inform the court immediately. I do apologise if I've overrun rather more than I intended.
Your apologies not to us.
Well, yes, and to my other friend.
Thank you very much. 2 o'clock, please.